Hello friends, welcome to our channel Steno. Subscribe our channel for more dictations on daily basis. All types of matters are available here. Complainant is a widow residing with her three daughters and one son at Mumbai. Her eldest daughter was married about 2 years before the incident. She was cohabiting with her husband at Khar. Her second daughter, who was aged about 19 years, and victim herein, who was 17 years, were residing with their mother. The victim was in 10th standard studying at a high school in Bandra. It was alleged by PW1 in her first information report that someone had taken disadvantage of her minor daughter, who was 17 years of age, and committed penetrative sexual assault resulting into her pregnancy. A charge was framed against the appellant by the special judge under Section 376 of the Indian Penal Code and under Section 4 of the POCSO Act. The appellant pleaded not guilty and claimed a trial. Defense of the appellant is of total denial and false application in the case by the police. The appellant had adduced defense evidence by examining four witnesses, including one doctor. With the assistance of learned counsel for the appellant, we have meticulously scanned the entire evidence of the prosecution and the defense. The main thrust of the learned counsel for the appellant is that the victim was major at the time of the alleged incident, as it has come in the evidence that she was born in the month of January 1996, meaning thereby she was 19 years old at the time of incident. The learned counsel would also argue that PW2, brother of the victim, and PW4, sister of the victim, have not supported the prosecution case. He also questioned credibility of the evidence of PW1 complainant, the mother of the victim, by contending that the report came to be lodged when the victim was 8 months pregnant, for which there is no probable or acceptable explanation tendered by the prosecution. Even the statement was recorded 5 days after the death of the victim. It is submitted that the mother herself did not know the exact date of birth of the victim, but she testified that the victim was born somewhere in the year 1996. Even this report, public witness was not aware about the contents of her first information report. Learned counsel drew our attention to the evidence of other important prosecution witnesses which were examined on the seizure Panchnama of victim's mobile, which according to him have not supported the prosecution case. A futile attempt has been made by the defense to rebut the testimony of PW1. Certain suggestions were given in respect of contents of the school leaving certificate, which indicated that progress of victim was not satisfactory and that she was repeated in ninth standard and was not good at studies. This cross-examination is absolutely irrelevant in so far as charge against appellant is concerned. Learned trial court has therefore rightly accepted and placed implicit reliance upon oral evidence of PW16 and the documents corroborating his oral version, conclusively establishing that the victim was a child and that her age was 15 years on or before 9/10/2015, which is the approximate time of incident. PW1, though, had mentioned victim's age as 17 years in FIR. Nevertheless, on the strength of aforesaid documentary evidence, it has been conclusively proved that the victim was around 15 years of age at the time of the incident. Indubitably, the victim was found to be pregnant of 8 months when she was examined by the doctor for the first time, meaning thereby when the offense of penetrative sexual assault occurred, she was about 14 years and some odd months old. The entry in the official register of the school is relevant as it was made in discharge of his official duty by PW16, who was appointed for that purpose. Turning to the charge under Section 376 of the Indian Penal Code and Section 4 of the POCSO Act, the prosecution has mainly relied upon the evidence of PW6 to PW10, who are all doctors and medical experts, coupled with the report of DNA examination conclusively establishing paternity of the fetus born to the victim. As already stated, Pw1, mother of the victim; Pw2, younger brother of the victim, who was then aged about 12 years; and Pw4, elder sister of the victim, have not supported the prosecution case for the reasons which needs no discussion, as it is apparent that they have been won over by the defense. The child born to the victim is indeed her legal heir and also a victim in view of the definition of victim, and therefore he must be adequately compensated for, as it was the appellant who is responsible for bringing him in this world and then abandoning him at the mercy of an orphanage. From the overall facts and evidence on record, it is apparent that the appellant could have been charged under Section 5 of POCSO Act. After the amendment of Section 6 in 2019, punishment for aggravated assault is with rigorous imprisonment for a term which shall not be less than 20 years but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of natural justice oblique life to of that person, and shall also be liable to fine or with death. Such a stringent punishment has been provided for committing an offence under Section 5 of the POCSO Act.